Well, good morning. I'm Trevor Morrison. I'm the Dean of the Law School here, and let me welcome all of you to NYU Law. For today's conference, Antitrust and 21st Century Bigness. I didn't know bigness was a word, but I like it. Dealing with tech platforms in a globalized world. This is an ideal topic to be taken up here at the law school, given our deep research and teaching strengths and interests in a range of areas implicated by today's conference: antitrust, intellectual property, information law, and privacy and data protection. And I am deeply grateful to the many people here at the school and beyond who were involved in putting together today's conference. Thanks in particular to the Hausfeld Law Firm for co-sponsoring today's conference and for working closely with our faculty to assemble such an outstanding group of speakers. I also want to thank Paul Romer, who recently joined our faculty in a joint appointment with the economics department as well. We're thrilled to have Paul as part of our faculty and thrilled that he'll be giving today's keynote address. My colleague Eleanor will introduce him in a moment. Let me also just take this opportunity to thank all of the other panelists and everyone else gathered here today to examine this important set of issues. And now with that, I will turn things over to Eleanor Fox, our Walter Derenberg Professor of Trade Regulation and a truly beloved member of our faculty. Eleanor.
Thank you so much, Trevor, for opening what looks to be a really exciting program. So let me just say a few words of introduction. I want to start out with a few thanks to those who helped organize the conference. And I want to introduce Paul, and then we will turn it over to Paul. NYU, with the Hausfeld firm, has organized this event on bigness, 21st century bigness, and it needs no saying that this is the topic of the day that is constantly evolving and unfolding, and we are right in the middle of it and not close to the end. So for thanks, I want to thank first some of our assistants, and from NYU, Nicole Arst, and from the Hausfeld firm, Kim Little, Kimberly Fetzik, Leah Costi, Marcella Villa, for all of the work that went in behind the scenes that made this possible, which is, of course, as you know, huge work. And then also, Harry First and I want to thank our cohorts at the Hausfeld firm and even elsewhere for putting together the agenda, thinking out the evolution of the issues and all of the panels. And we worked very closely with Michael Hausfeld, Irv Scher, Scott Martin from the Hausfeld firm, and also worked very closely with Larry Sorkin. So Harry and I thank you all. A word about the topic before I turn it over to and introduce Paul. We're in the middle of this unfolding saga of big tech. And to many, it seems that big tech has taken over our lives in various ways, influenced our lives in various ways, and to many people, engaged in many abuses and unaccountability. And the big question of the day is how to call big tech to account. So in the US, we have what we call the GAFA symbolically, because it's a little bigger, but that's Google, Apple, Facebook, and Amazon. And the special characteristics of these markets that make them distinct and make the harms that seem to be evolving distinct, including the huge network effect and the winner take most of the markets. And the fact that one side of the market looks like it's zero priced, which makes it very difficult to fit into some of the antitrust analysis. And in addition to what might be pushed into an antitrust analysis, there is a huge public debate about bigness. Are these companies too big? They're bigger than countries. They are acquiring data from all of us on our lives and various aspects of our lives and misusing it in some ways. And there is a movement to, as you know, to break up big tech. So this is one of the things we will talk about. I mean, that is the bigness issue. There is separately the antitrust issue. There is the array of possibilities of various disciplines, such as data protection, of course, comes in very much in the forefront. Data protection, consumer protection, various possible deceptions, and where is the piece that antitrust fits in. There are investigations, as you know, all over the world. This is not just a US issue. The investigation started elsewhere. Investigations in some cases, Germany, EU, UK, Australia, South Korea, and in US, Federal Trade Commission, Department of Justice, almost all of the states of the United States. It is a multi-level chess game. In US, as we said, we have GAFA. In China, they have BAT, Baidu, Alibaba, and Tencent. In Europe, they have industrial policy. You might laugh, because they have a lot of antitrust too. And the issue, the markets are world markets. The issues are international issues, and we have each nation or jurisdiction trying to solve it independently. So we do have this program coming up. I just want to give you a quick glance through the program at how the program will evolve. After Paul's speech, we have our first panel on monopolization and abuse to talk about how our US unilateral conduct law and also EU abusive dominance law can rein in and discipline big tech. We then do something similar about how the existing law can rein in big tech on mergers, including killer acquisitions. We then have a wonderful lunch conversation planned for you, in which Tim Wu, who is the author of The Modern Curse of Bigness, will be interviewed by Steve Calkins, and then in the afternoon, we'll talk about solutions. And we'll talk about solutions under current law, and then we will talk about solutions, perhaps legislative, that are not under current law. And thanks in advance, all of you who are participating in these panels. So let me turn to our first star of the day, and that is Paul Romer, whom I'm very happy to say is our colleague at NYU Law School. He's a university professor at NYU. He's a professor of economics, also at the Stern School. But we at the law school are very proud to claim him because he's located here. So Paul is a pioneer in endogenous growth theory and integrating technological innovations into long-run microeconomic analysis, for which he was the co-recipient of the Nobel Prize in Economics in 2018. This, of course, was a culmination of a lot of work on economic growth, and his work has enabled economists and others to ask new questions about modern knowledge economy. Where do ideas come from? How do ideas spread? And he has focused in his work on cities, urban, clusters of people as the center for the spread of ideas. And so he has masterminded the idea of charter cities in developing countries as a locus for developing ideas for markets for the developing countries. All of this was reported in this wonderful article about your visit to the Burning Man, sort of primal bacchanal in the desert of Nevada, which is an instant city growing up almost overnight in just a couple of days, and then dismantled And I was intrigued and read that article before I met you. And I always wanted to go to Burning Man, but before it became a celebrity site. And this was the laboratory, a laboratory for Paul to study instant cities and the growth of cities and creation and ideas. So winding back, Paul was a professor on economics faculties and business school faculties and university faculties, a number of distinguished ones. When he was at Stanford, he actually was called upon by the US government in the US against Microsoft case and testified at the relief phase about the effects of the behavior of Microsoft on innovation and how that gave rise to an idea of unleashing innovation by an idea which didn't happen of the separation of the operating system from the applications. Then Paul was recruited by NYU Stern, where he created a new institute on the mechanics of cities. And then after that, he joined the World Bank and was a chief economist and senior vice president, and then returned to NYU and is here now, we are happy to say. So while he was at Stern and learning urban planning, learning more about urban planning, one of his colleagues was Alain Berthaud, who said the following, because I wanted to quote this. The beauty of the mind of Paul is that he sees patterns where we don't see them, because he sees patterns across examples which seem to have nothing to do with each other. So I think we need you, Paul, because I think at this moment we need to see patterns across examples that may seem to have nothing to do with each other. Another quote I want to quote is a quote of Paul himself, who has said, "A crisis is a terrible thing to waste." And he said it in connection with education. But I want to say, I think we are in a crisis, and it would be a terrible thing to waste this crisis. And we are therefore extremely grateful to have Paul here as our keynote and to have the evolving program. So Paul will talk to you about the institutions for formulating and regulating competition policy and some of their comparative advantages. Thank you very much. So this belongs here.
My father was a politician. He is governor of Colorado for 12 years. And by the way, I have a cold. I apologize for the hoarseness. But one of the things he taught me was that the key to success is to beat expectations. So, Eleanor, you've set me up to fail with expectations like that. There's no way I can beat expectations. I'm going to just improvise and add something in that I was thinking there wasn't time for, but just is illustrative of this approach that I do tend to take, which is to look for patterns. I first started paying attention to the concept of the business model when I was thinking about infrastructure at the World Bank. It's a term that I borrowed from the tech world, where they talk about, okay, we've got this startup, they're like indexing the web, they're getting a lot of eyeballs, we have no idea what the business model is, but we'll figure something out later. It's an interesting abstraction because it sits above technology, but below the usual alternative we think about, which is something like power and control. And I think my wife said to me recently after listening to me about something, you know, Paul, your whole thing these days is it's the business model, stupid. And I think this is actually very true. So let me give you some examples. So Google could see there was big social benefit from indexing the web, but they had to figure out a business model. Turned out it was advertising. It wasn't clear in the beginning. Who knows what the business model is for airports these days, or what it's become in the last 20 years? It used to be landing fees. And what do I mean by business model? It's not like the capital structure, forget that. But what's the revenue stream? It used to be landing fees, like fuel taxes. Yeah, exactly. It's retail, it's real estate development. This has completely transformed the economics of building airports. And like, who the hell cares whether it's government-run, government agency-led, or private sector under some kind of concession? Either way, it doesn't make a demand anymore on general revenue. One of the challenges that we face, the early stage of my career, I was focusing on the production and distribution of ideas. And in a very deep sense, we have not solved the problem of what's the business model for people who produce new ideas and distribute them. Ideas turn out to just be profoundly different in a way that, if you think about patent law, is obvious, profoundly different from physical objects. You've got a physical object like a pasture. It helps to have property rights, so somebody controls the overgrazing in each piece of property. But if you think about a discovery like the way to save the life of a child who's likely to die from something like cholera, there's this formula that they refer to now as just oral rehydration therapy. They die of diarrhea, you just got to get them enough fluids. But if you just give them water, you'll kill them from an electrolyte imbalance. If you put in some salts and minerals to avoid that, that helps. But if you put in some sugar, it tends to increase the uptake. So there's this little homemade kind of recipe you can teach anybody to make. It just saves millions of lives. So like search, that was a very valuable idea. But what's the right price for that discovery once you got it? How much do we want to charge every parent who's trying to save the life of their kid? So set aside how you'd implement the charging. How much do we want to charge for that? Like nothing. So you've got this contrast between expensive exploration and discovery of potentially very valuable things, which you want to motivate, and ex post efficiency that implies giving things away for free. We don't have a model like we now have for airports for things like the power grid, which is the kind of issue I was thinking about at the bank. But more deeply, we don't have it for like pharmaceuticals is at best an uneasy compromise right now. And in the whole tech world, I think what we've seen is a rapid evolution of this model into advertising, which now leaves us in, I think, a very perilous state. So let me just scroll back then to, then I'll return in the end at this issue of how important it is to innovate, not just in terms of technology, but innovate in terms of the business models. And when we think about regulation or legal intervention or legislation, I think we should always be focusing not on AI or any other manifestation of the technology. What we can influence and what will drive everything else that happens are the business models that firms use. Let me just give you one other one. Jimmy Wales says that when he was setting up Wikipedia, the most important decision he made was to prohibit the use of ads. No advertising revenue, ever. Now, this is a nonprofit firm. It's a bunch of public-spirited people. So why did he still feel like he had to constrain the revenue that was available to them? He knew that this business model, if he adopted it, would completely distort the mission of the organization, and that even as the person nominally in control, he could not resist the pressures that this would unleash to completely divert them from their mission of making the world's knowledge available to everybody. Okay, so now let's scroll back just a minute to talk about innovation. The gist of my work was that most valuable innovation happens in the private sector. We can't just think of you give money to scientists at the university, they discover things and then nice things happen. That's a part of it, but most of that discovery of valuable ideas happens outside the university. And if you create the right incentives, we get a lot of innovation in the private sector. So that was the sense in which I was talking about endogenous growth. This message can too easily be distorted into the message that you just have to let the market do its thing. And that was never my intent, and I'll come to how bad I think things can be if you just let the market do its thing. But to give you just a simple example of this, think about innovation in the chemical industry. I think it was Dow discovered this class of compounds, chlorofluorocarbons, They're very safe. You can use them to extinguish fires in like a submarine. They seemed like these wonderful things. They're very useful in refrigeration. We used it to spray underarm deodorant back when I was a kid, not many of you. But it turned out that these chemicals had this side effect that they were destroying the ozone layer and were going to endanger the possibility of life on Earth. So it's an illustration of the fact that to make progress, we have to have both innovation and regulation. And I'm not shy about making this case. Everybody likes to complain about regulation, but you need some collective capacity to stop activities that are profitable but harmful. And exactly how you implement that, I think, is the difficult challenge. But there's no way to make progress without some collective capacity that almost always operates through a government. And then what you can do is you can say to the private sector, yeah, just go innovate, discover your things. Some of them are going to be good. Some of them are going to be bad. Some are going to be bad in a really dangerous way, in the sense that you can make money off of them, but they're going to do net harm. And we just need, in parallel, something that shuts down the things that do harm. In this realm of ideas, there's always attention that's drawn to the things that would be beneficial but aren't profitable. Government has to subsidize. We got to get more of that stuff. Yeah. But we're professors. Send us money. It's a great argument. But there's the other box, which is the things that are profitable but harmful. And this is, I think, where the future of civilization is going to get determined. Now, let me just comment briefly on what I take from the Microsoft case. I wrote a declaration. If you just search for DOJ and my name, you'll find it. I went back and read it recently, and one of the values of codifying your thoughts is you can look back and see, okay, what did I get right? What did I get wrong? The only way to learn is if you keep paying attention to what you got wrong. Where I think we were right, and Dan was involved, and you could talk about this as well, where I think we were right was that we predicted that Microsoft would completely dominate this business model of licensing or purchases of software. It was very hard to see how new entrants could make a go of it if they were going to try and compete in the sale of software. So the remedy, the apps-ops split, was designed to at least have two different entities that could be viable in this realm of software licensing. What we didn't anticipate was the emergence of the advertising business model. This business model, I want to argue, this is reasonable people could differ on this, but I think this business model is as dangerous as the chlorofluorocarbons. So the main takeaway for me from the Microsoft case is that the massive uncertainty about the effects of a policy intervention in a rapidly emerging market like the tech market. At the time, I thought a key indicator of success of our efforts was whether or not we could keep Chrome alive, because Microsoft could make it very difficult to switch to Chrome, and then Chrome wouldn't survive. There'd be no competition in the web, and that would stifle innovation. We kept the conduct remedy actually did protect Chrome. Chrome then grew into this, has helped foster this colossus at Google, and it's doing way more harm than Microsoft was doing. So we have to think about, how do we want to implement this regulation imperative that I talked about earlier in practice? I don't think that the judicial system is the appropriate mechanism for dealing with decisions under profound uncertainty. If you think about somebody's got cancer, and imagine that to get them out of a treatment regime into some other treatment regime, what you had to do was bring a lawsuit. Okay, now who's going to bear the burden of proof? How much discovery do we want to allow? How many appeals do we want to allow? And how are we going to do this before the person dies? you just don't want to use the legal system and property rights to try and make some decisions about cases like this, where there inevitably is going to be a huge amount of uncertainty. So I'll talk in a minute about the alternatives to the judicial system. But let me just elaborate just a bit on where I think we are. And I'm going to just be very blunt. I think that, well, let me ask. George Soros has been saying that Mark Zuckerberg is trying to tip the election in favor of Trump. Set aside the question about what Zuckerberg is or wants to do. How many of you think it's possible for Zuckerberg to tip the outcome in this election were he to decide to do that? Okay. This is more than I usually get. I have a way that I kind of test an idea like this, which is I pose it to a lot of people, and then I look at what I call the Brand derivative after Stewart Brand. Stewart said, the more you know about nuclear power, the less you worry. The more you know about global warming, the more you worry. And so stealing that idea, the more people know about the advertising market, the more likely they are to say that Facebook and Zuckerberg could actually tip this election. So that kind of progression, more understanding leads to more concern or a higher probability that this could happen, persuades me that there's something very real about this. This is really a profoundly troubling case. And it's unusual, and Zuckerberg, compared to Google, is the one to focus on because there is nothing that constrains what he can do. He doesn't have to answer to a board because he's got majority control. He can do anything he wants. If he wants to bias the news feed in favor of one candidate or another candidate, it's not against the law. It's not going to violate campaign finance. He's got to worry about his employees, but because they might, he might lose some of the employees. But this is a level of concentrated power in the hands of one person that I'm not sure we've ever seen anywhere in history. And whatever his intentions are, whatever kind of a person he is, we should never have allowed this to happen. And just to be clear, Facebook is positioning itself to have this kind of power in countries all over the world. So, and very, very effectively. So, is big bad? Absolutely. No question in my mind. Is it helpful to try and frame big as bad exclusively through this lens of the consumer surplus and deadweight loss? No, it's not. There are more important issues like the survival of our democratic system and just a general fear and concern about unchecked power in a world of great uncertainty, which says that we should never have let this much power accumulate in the hands of just one person. Now, how are you going to respond? I don't think there's any hope that you could break up Facebook through an antitrust action. So I'm not even going to think about the question of whether it would be good or bad to do that. It's not going to happen. If you just look at the, Ohio versus Amex case and the Supreme Court's decision in that case, this was a structural remedy. I mean, this was a conduct remedy, and they weren't even willing to accept that. And they used economic theory to sort of like just amplify all of the uncertainty about what could happen. There's just no way that our judicial system is going to break up Facebook. The one alternative would be to use the executive branch. I'm on the record as saying that the FAA plus the NTSB was the gold standard in regulation in the United States, because the NTSB was the fact finder with no obligation for making decisions that held in check the FAA and the airlines, and was a very important part of how you prevent, traditionally how we prevented capture. But we now have seen how Boeing was able to eviscerate the FAA and the regulatory system that it used to work, but managed an incredibly complex domain, made it very safe. That system has been, really dramatically undermined if you've paid any attention to this case. So what alternatives are there? I think the only way forward here is in the legislative branch. These are hard decisions, they're contentious, but if, as a society, we're going to say, we're not going to allow the kind of power that Facebook has accumulated. That's not the society we want to live in. The only way to address that is for citizens to push their elected representatives to pass laws that stop the behavior that they don't want to live with. And if that means big is bad with no reference to efficiency, and just take your economists and send them home, that's what the voters should do. I've personally been pushing for a tax on targeted digital advertising, with the understanding that, of course, the national government's going to do nothing, but the states are actually getting interested. Maryland's already introduced a bill. Others are kind of paying close attention to this idea of an excise tax on digital ads, with a view towards pushing the entire industry out of the advertising model into some other model, like the subscription model, which we know works in this domain. It's the way markets have always worked. I just can't believe it that there's this conversation about, hey, the market couldn't work if people had to pay something to get something. Like imagine if you had to pay money when you go to the grocery store and take groceries home. That would never work. So the subscription model is the way markets are supposed to work, where people give up something and they get something. So don't get me started. And then let me just close with an advertisement for something I read. There's a review I wrote of 2 books about economics and foreign affairs. Foreign Affairs has a paywall. It's like that idea which you now have to pay for. But if you go to my blog, at least in the next week or two, there's a link. There's a blog post called What Went Wrong. There's a link that'll get you into the review at Foreign Affairs. And the conclusion I came to, really very reluctantly, on the basis of the arguments in these 2 books, is that if you do a cost-benefit analysis and say, take the world as of, say, 1960, and then imagine a world where economics does what it did, which was completely take over the discourse about policy in a country like the United States, and then contrast that with a world that continued to function the way it did in 1960, what's the net effect of this reliance on economics? And I think what this is going to show is a large number of very small benefits associated with the application of economic analysis, and a couple of massively damaging harms. One is the tolerance for support for a financial system, which is so dangerous that it's really done damage in the just most recent crisis, 2008-9. That's hard to comprehend. I try to measure it in terms of Chernobyls. Like Chernobyl is about 200 billion in harm from the Chernobyl nuclear accident. The financial crisis of 2008 was just like 1,000 Chernobyls. It's not like 100 or 10. It's like thousands. But the other one where I think economists have really done harm is by fostering this narrow focus on efficiency and attending to the uncertainty in antitrust, and therefore, and expressing concern about we don't want to stifle the innovation. But the net effect is that we've really, as a society, scaled way back on our traditional emphasis on keeping firms from becoming too big, keeping markets fluid and competitive. And if the harm of that second intervention or the second effect of economists is to actually undermine democracy, it's going to be bigger than the financial crisis. So, I concluded in this review that I think the net effect of economics has been negative. I think we're not making progress in the United States anymore. People are dying younger. That's a pretty good sign. We're not moving forward. And I think economics and the discourse and the methods of economics have been part of why we got off track. Because it undermined that capacity that I talked about in the beginning, which is to say, we don't care if you're making money doing it. It's bad for the planet, and you're going to have to stop. Economists have basically undercut our ability to make that kind of decision about what kind of world we want to live in. So on that cheery note, let me leave it to you to think about what is the more narrowly scoped role for antitrust law in this kind of world. And if you don't think legislatures can deal with this problem, what could? Thank you.
Thank you. That was wonderful, very provocative. I'm sure you will have some provocative questions or comments. And we do have about 10 minutes for questions, conversation. And
in my world, if you say something like, "Oh, that was very good. I'm really glad. Thank you for sharing that." That's like what I say to a PhD student I'm trying to counsel out of a PhD program. So the way you show respect is, "Paul, you're wrong. Let me tell you why." So don't
no, we're going to
don't
look
pull
for
your punches. Yeah.
We're going to look for the patterns and work with them. So who would like to start the first question? Well, I can do that, but I know that there are probably many of you who want to. So let me just start here. I'm a little depressed. Secondly, depressed in thinking of what are good solutions. Yeah. And assuming, because you have me on board, of all the big problems that you have outlined, and you think that the legislature is the right place to look for solutions, I gather that some of your solutions will be regulatory as opposed to antitrust opening up to be more aggressive. And some probably will be in the area of speech obligations. I mean, this is the obligations of big tech to not pollute the tech airways. Could you say a little more about where you see the legislative solutions? And given this audience, too, could you say a little more of, do you see any room for opening up antitrust to be more aggressive? Do you see any room for that to be a cure?
Yep. Well, first, I think merger review is an easy place to tighten up. And I'm not at all worried about going too far or going overboard on that dimension. So just crank up the merger review and just, stop as many as you can, frankly. But, you have to have some kind of process for doing that. But I think that's an easy thing we could try and rebuild. If you go back to my example of the NTSB and the FAA, I think it's incredibly powerful when a government can surface trustworthy information that's accurate. This can have huge implications, even without any follow-on legislation or regulation. My saying about this is that information creates its own incentives. So I think the FTC is really vastly underutilizing its ability to find out more about what's going on in these markets and making sure that everybody understands what's going on. We traded emails, and I didn't tee up your question, kind of the concern we addressed as effectively as I might have. But when we were going back and forth, where I was saying there's less role for the judicial system, if I say that I want to pass legislation like an excise tax, of course you're going to have some enforcement mechanism. There's going to have to be some way to impose penalties if somebody doesn't pay the tax. But I think what we need to think about is that these mechanisms of the judicial system, like a burden of proof on the government and a high burden of proof, mean and an action based in a case where you can prove a violation of the law. You can't just act to, like the thing about chlorofluorocarbons. You couldn't use the judicial system to ban chlorofluorocarbons because there's no obvious law that Dow had violated. But so you can use the judicial system, I think, only with clearly defined notions about what's allowed and what's not allowed, and then consequences that follow from that. So legislation that says we're just going to tax, from my perspective, it is at a higher rate as we can, targeted digital advertising. We could set up, we've got systems like the IRS or the state agencies that can do audits that actually put the burden of proof, as they should, on the taxpayers. That kind of system could then ultimately lead to a few cases of tax evasion that go to the courts. But what I think we can't do to the courts is say something like we were saying in the Microsoft case, which is like the future of tech and innovation in this country is in your hands, Mr. Judge, and you need to, in this realm of extraordinary uncertainty, make a decision about a remedy which will, lead to a better future. I think judges are just not in a position to make decisions like that, and they don't want to be in the position of having that kind of burden on them. So I think the big questions, like, are we going to just put some kind of absolute limit on size, or are we going to put a tax on this particular activity? These things have to be clear and easily enforced. It means they're also going to be like ham-handed. You're not going to be able to make fine distinctions with legislation that's clear enough that somebody can actually enforce it. But you just accept that as a cost of life. Somewhat arbitrary distinctions are the essence of an enforceable legal system, and we should just accept that and not complain about it. So I think there's still an important role for the judicial system, but I think it's much narrower than what we've been used to.
Judge Walker. So Judge, would you say your name? Judge, this is Judge Walker. I just wanted to introduce you.
Okay. And I first called
And do you want?
Supreme Court case a number of years ago.
Yeah.
The question is simply,
I think he was on the wrong side of, I know at least one of them, but probably
my
two.
question is simply this. Having witnessed the conduct of the Congress of the United States in the last several decades, how is it you can have more confidence in a legislative means of addressing technological change and problems than you can the combination of all the other forces at work?
Yep. You could have prefaced that with, Paul, you're wrong about legislature. But so, A minus. I think that the bet here, and it's an uncertain bet, but that if we start to think about a much more active role of the states, what you'll see is some that are captured and some that are dysfunctional, but some that will actually be able to make decisions. And then amongst those that make decisions, if on average things turn out better in those states, I think that will create pressure for others to follow. It's a little bit of a weak reed to rely on, but I don't see any other way forward.
You seem to be positing a free market in legislative solutions.
Yeah. Well, people can move, and that's I think what we'll see. So I would not predict that all states will take appropriate decisions, but I think some will, and that would get us out of the paralysis we're in.
Did you want? Okay. So Judge Walker does raise this very interesting and important question, and I'm sure we'll discuss it more today, that is it possible that the free market is more trustworthy as an Uber institution than either the legislature or the court system and antitrust, that there is such uncertainty, there is such a thing as dynamic disruptive innovation, that maybe we're better off with the other side of the coin from your speech, of leaving it to the next disruptor who will throw over Facebook and Google.
Yep. That was what I used to believe, but I now think the trend in terms of honesty in communication in the corporate sector is sharply negative. I mean, honesty is going away, and the tech sector is way out front in the lead on this. There's really just an astonishing degree of deception and misdirection, and just try and find out I have dog walkers. My dog walkers wanted to use some, smarty pants tech solution to send me bills. So I write to the head of this little startup and say, okay, tell me who gets my financial information. And this woman writes, well, I use such and such provider, big name. Everybody uses it, it's okay, but what do? Do they know every single charge about me that goes through them? So I don't know, I don't care. So, but you gotta go to the kind of lengths I went to, but I still never got any information about what would, who would get my information about, spending money on dog walking. So it's impossible as a consumer to find out what you're actually getting engaged in when you enter into a transaction that involves any of these new firms. So, and I think if you look at the communication from Boeing, it was just astonishingly dishonest, and caused the loss of lives. I mean, I think this case is much worse than I think people have fully recognized. So no, I don't see any hope at all that what we're going to get is more trust, more honesty from the free market. Now, if it were a truly competitive market, I think there'd be a lot more hope. And on your question about free speech, just think about the world when there was the National Enquirer, but the New York Times and the Washington Post and none of those entities felt like they were engaged in censorship if they refused to publish your letter about Bat Boy. And the National Enquirer would publish it. You could read about Bat Boy if you wanted to. But people tended to gravitate towards the more trustworthy of those. So I don't think we need any intervention here other than what it takes to get competition between various providers of platforms for communication.
So we have one more question, and it will be the final. And Dan, could you pass over the microphone?
Paul Kaplan. It seems to me that the foundation of any monopoly analysis has to start with Grinnell. And my question for you is...
Start with what?
With the Grinnell case, this U.S. Supreme Court case.
I don't know that case.
Just the dichotomy between acceptable conduct through maintenance and acquiring positions lawfully versus acquiring a position through superior product and good business acumen, I guess, is the dichotomy of the court. My question is, how do you deal with the structure that the Supreme Court set down in that case in terms of analyzing monopolies going forward?
By the way, this is the single best thing about getting a Nobel Prize is I can admit when I don't know something. So I don't know that case. I'm not in the antitrust business. It was just like I got pulled in briefly on the microphone. And actually, I only know about Ohio versus Amex because I was invited to give a talk at DOJ, and some of the staff people there says, hey, just read this, take a look at this decision. So I think the premise of your question is that we do need to make a distinction between bad conduct that leads to monopoly and good conduct that leads to monopoly, and I don't accept the premise. I think even if Zuckerberg had gotten to this position of the power he has without making any decisions, taking any actions that violated existing law, I still think we want to, just stop this, break this, put a check on that kind of accumulation of power. So, and I think that one of the problems here is we've gotten stuck in a very narrow frame. But if you think about a decision at that level, which is that independent of the facts in the particular case, independent of notions about violations of the law, we're going to put restrictions on the size or the power that any individual or firm can accumulate. I think only a legislature can make those kinds of decisions and make the hard choices about, okay, to implement this, we're going to have to be somewhat arbitrary, but we're just going to make that decision. So there may still be a role for a legal distinction about permitted versus unpermitted acts, but I fear that it's going to be it's already a very hard distinction to implement, and I think the resources of the firms that could be prosecuted here are just so vast that we're never going to get a good policy outcome out of a system that's going to depend on drawing those distinctions. I mean, just look at how the IRS was just overwhelmed by Facebook in their case about the the use of Ireland as the tax shelter for Facebook's income. So, so again, I'm just very pessimistic about what we can get out of the legal system.
So you've shown, Paul, you don't have to be an antitrust economist to have absorbed exactly that question. I mean, do you need willful acquisition and maintenance of monopoly power, or just is it wrong and bad for society? A question we will debate today. That's in our title of our program of 21st Century Bigness. We'll debate lots of other questions. We'll have lots of arguments too, which I will say is on the other side of the coin, that maybe the free market is maybe more robust than you say. This was a fantastic opening. It really teed up.
Can I make a small amendment? Let's say that was the last answer, but there was somebody who's been standing waiting patiently, so you get to ask the last question, and we'll leave it hanging.
Oh, thank you. Does this microphone work? Thank you. Despite recognition, thank you for your wonderful presentation. I think it's interesting that these views were, I don't know if derisive is the right term, but somewhat ironically characterized as hipster antitrust, these kinds of neo-Brandeisian views, and yet we have a Nobel Prize winner on that side, so that's really great, I think. And I started reading the Burning Man article back in the day, but I haven't finished it. The New York Times Magazine articles are very long. But I'll get to the point. I'm wondering, in terms of the actual bigness, I don't know, just to push back a little bit, I don't know that I totally agree with you that in itself, bigness is always that. Like, even if you think, obviously, to other countries, like state socialist regimes, obviously, for a while, they enjoyed substantial economic growth with, pretty important concentration of resources. I mean, even in American economic history, before antitrust came into view, sure, there was inequality just like today, but it's not as though there was no economic growth in the days of Rockefeller, Carnegie, and these guys. I mean, there was tremendous growth and tremendous development. And so, moreover, I think we derive value from the fact that Facebook is big, for instance. Like, for me, it's much easier to just be on Facebook than to be on MySpace, TikTok, all this stuff. Some friends are there, some friends are here. That's just inefficient. So I'm wondering, maybe it's better when we think about solutions, instead of like breaking up the Facebooks of the world, to put public representatives, like someone from the US or from the EU, like just kind of basically nationalize, but somehow nationalize without killing off the innovation. So that's kind of tricky too. Thank you.
I promised I wouldn't answer, but this raises all the questions that we should be discussing. Thanks.
Okay, thank you. That was really fantastic. Wonderful start of the day. Thank you. We're going to our first panel right away. Harry first. Where are you? Here you are. Okay.
So I'm now going to announce the winner of the car. If you're seated and look under your seat, you may find the keys to a new Pontiac. I just thought I'd try to give people the Oprah incentive. You may have won something if you're sitting down. So first of all, I want to thank you all for coming. The usual thanks to all the organizers, but since I helped organize this, I'm thanking myself, which is immodest. We always thank the staff who works on these programs, and they're always outside working and never hear it. So if you go past the table, thank them and tell them they were thanked inside.
Let's give them a loud round of applause that they can hear.
You have to open the door. What a great idea. Okay. As Paul Romer said, ideas are everything. We just can't monetize that one. Welcome all of you again. We have a full day, as Eleanor said, trying to dig into some of the issues which that really Paul teed up for us. As I heard Paul, I thought he was saying, we should throw out the economists. Usually it's the lawyers that people want to throw out, so I found that refreshing. And I was sympathetic, but I want to sort of tee up this panel. The topic of our panel is monopolization and abuse. So I want to tee up our discussion of monopolization actually with two reports by economists, which I think sort of bookends our debates in a way. And there are two reports of the Council of Economic Advisors. One was an issue brief done in 2016, Benefits of Competition and Indicators of Market Power. And in that report, which I'm sure many of you are familiar with, the CEA sort of put together what was felt to be the research view at the time, concentration increasing a lot. Profits were increasing, but entry into markets was declining, which is, of course, not in our nice antitrust world the way it's supposed to be. Other data that was circulating at the time supported the idea that profits were high and entry was low, plus a critique about income maldistribution as a real problem in society, Thomas Piketty's work and others. The other end of the bookend, which I'll get to in a second, is the CEA annual report submitted to the President on February 20th, 2020, just before our conference, because they knew the conference was taking place and they wanted to get this out on time. No, that wasn't their timetable, but it's helpful, and it takes a very different view, which I'll get to in a second. So around the time that that first CEA report came out, people were saying things like this, that pretty good evidence exists that since 1980, about the time that Robert Bork's book, which you all know, The Antitrust Paradox, was published, and United States antitrust law began a significant rightward turn, market power measured by price-cost margins has been on the rise. So this is written by a law professor, not an economist, but drawing on economics. Accompanying this has been a sharp, dramatic rise in firm profits, but stagnant, virtually non-existent growth in wages. So again, this concern for some of the broader issues that Paul Romer teed up for us that sometimes has escaped antitrust analysis, and one of the issues that we're going to try to think about as we look first at monopolization law. At the same time, a lot of interest in the public press and in general, in other words, in the world outside of us antitrust lawyers, about the problems of big tech and the big platforms. So a quote from Farhad Manjoo, who was at that time the tech columnist for the New York Times. We are, all of us, in inescapable thrall to one of the handful of American technology companies that now dominate much of the global economy. So he called them the Frightful Five, which in some sense is the big tech that we're talking about today. So Google, Amazon, Facebook, Apple, and Microsoft, the through thread from Paul Romer to probably the very end of our discussion. So to get a sense of how these five companies have altered the economic landscape in the United States, in 2006, if you look by market cap, the top five companies were big oil, ExxonMobil, heavy manufacturing, plus other things, General Electric, and banking, Citigroup and Bank of America. Those are four if you're counting. The fifth was Microsoft, so that's 2006. By 2017, the other four had been replaced by Google, Amazon, Facebook, Apple, the through thread, Microsoft. So the economy has shifted. That's one way of thinking about it. At least before the coronavirus, those top five companies, each in about January of this year, each had a market cap value of over $1 trillion each. However you want to cut that, it's a lot of zeros. About 17% of the S&P 500 index, those five companies. This is important, all right? So we may want to throw out the economists, but it's at least important economically and important in other ways that hopefully we're going to discuss. So one of the questions that Paul Romer, I think, raises that, of course, is important to us. He trains PhD economists and tells them not to be economists, but we train lawyers here and we tell them to be lawyers, or we'd like them to be antitrust lawyers. So we hope antitrust is still relevant to this. And the question is that we're going to face is how is it one of the obstacles? We've often, at times of structural change in the United States, called on antitrust to respond. That's how we got the antitrust laws in the first place, 1930s. In the midst of the Depression, antitrust eventually responded. We had one of the strongest times for antitrust enforcement under Thurman Arnold. The turn of the new economy at the turn of the millennium, when we discovered that the digital economy was on us, the antitrust enforcement responded then, again with Microsoft and the antitrust monopolization. That's wrong. It's the Antitrust Modernization Committee, not Monopolization Committee. A little slip of the psychological tongue there, which came out with its report in 2007. So we've looked for antitrust before at these times, and there's a call now, as we all know, to look again, both in terms of an enforcement or litigation response and a legislative response. And this panel is going to explore particularly the litigation response and whether antitrust law is up, sort of fit for the task, is up to it. I'll sort of end this. I'm not Paul Romer. I want to end the introduction, in a sense, for this part by the other side, this current CEA report. Interestingly enough, as Paul Romer said, bigness is bad. This report goes out of its way and says specifically, bigness isn't bad. We like it. In summary, many digital platform markets have demand and supply features, suggesting that high concentration is efficient. Concentration has led to concerns about market dominance, anti-competitive behavior, and a lack of competition, but concentration could also be efficient, and there may be robust competition for the market, even in the face of high concentration. And throughout its development, antitrust law has consistently proved flexible to the evolving market conditions presented by new industries and business models. Before making radical changes in the law, the case for such change should be better grounded. So that's the challenge from that bookend of the current CEA report. Quick search for the mention of Section 2 in that report, none. Well, they do say there is a Section 2, so one. I don't want to exaggerate. So we're going to turn to Section 2 and see what we do have and what the problems are, or perhaps the potential of using Section 2. I think, as Eleanor said in the beginning, but we all may want to try to fight pessimism throughout the day and see if we can find that there really is something that we can do. So our panel, and this is in the order, you'll notice, not alphabetical, but the order in which they're going to give their initial presentations, about 5 minutes, and then we'll start our own discussion and bring you in as well. Andy Gavel, first up. I'm tempted to say for everyone knows all of these people. It's probably not true, so I'm going to do a little introduction, and you have it in your programs. Teaches antitrust and civil procedure at Howard. He has written an excellent, probably the best book about Microsoft antitrust cases. See, this is the inside joke, because Andy was nice enough to ask me to co-author with him. So it is a great book. And casebook author and so forth, spent 2 years at the Federal Trade Commission as director of the Office of Policy Planning, so that connection with government enforcement. Dan Rubenfeld, one of my esteemed colleagues on the panel, professor of law and economics emeritus at Berkeley and professor here. Recent work in digital markets, but Dan has just written so many things, including important economics textbooks, and is a highly sought after economics consultant. and had been the chief economist in the antitrust division from June 1997 through December 1998, and involved with, I won't tell you the name of the case. Thomas Hoppner, professor of antitrust and intellectual property at Technical University Wildau in Germany, and a partner in the Berlin office of Hausfeld, and who also publishes widely in antitrust. And he has represented a number of complainants before the European Commission in various proceedings against Google. So he knows the European side of things quite well, and just argued before the EU General Court in the appeal of the Google shopping case. So next is my esteemed and inestimable colleague Eleanor Fox, Walter J. Durenberg professor here, published about everything. She has won more lifetime awards than anyone should win in a single lifetime. Sort of unfair competition, I feel. And is, if I have to pick a scholar who is broad in terms of antitrust, it's clearly Eleanor. Her latest book, Making Markets Work for Africa, shows her interest in using competition and markets to deal with issues of poverty, which is not normally a topic for antitrust discourse. And finally, Bill Kovacic, at the end of the table, but not at the end. I asked Bill to send me a bio, so here it is. A model of understatement. Global competition professor of law and policy, George Washington University, visiting professor, King's College London, non-executive director, UK Competition and Markets Authority, former chair, US Federal Trade Commission, and he's left stuff out. Former general counsel of Federal Trade Commission. He was a commissioner before he was.
We could go through it all.
We could go through it all. I mean, to go through it all would be the same as trying to follow Bill flying around the world, advising competition authorities everywhere about how to do things better. So he's probably, if you had to pick a scholar who writes about the institutions of competition law and how competition authorities can work well, the leader on that list would clearly be Bill Kovacic. So the great panel, and we're going to start out, as I said, with initial presentations from them all. So I am now going to get out of the way and let you hear from them. Andy.
Good morning, everyone. Thank you, Harry, and thank you, Eleanor, for inviting me to join the panel today on a topic that obviously has engendered a lot of discussion in our community and more generally. I'm going to sort of pick up with the last question. What I want to try to do is answer the question of where our basic legal framework for monopolization came from. What is the history of it? How did we get to cases like Grinnell? And I'm actually going to start back in 1905 with the Swift case and the Alcoa case in 1945, both of which have proved to be extraordinarily durable in setting the legal framework that we use. And I'm going to talk about how that framework has in some ways proved to be flexible, but in other ways has proven to be very inflexible and is constraining the ability of Section 2 to adapt to the circumstances of today. But somewhat influenced by Paul Romer's comments this morning, I want to start briefly by talking about taxi regulation, and hopefully you'll see why I've made that choice. When I was at the Federal Trade Commission in the policy office, companies like Uber and Lyft were just beginning to come onto the market, and they faced challenges from the incumbent taxi industry. But they also faced challenges from the regulations that had been perpetuated over many decades in the taxi industry. And those years of regulation were based on a snapshot of what the market looked like and what it should be. And so when you looked at those regulations, there were taxi cabs and black cars and limousines. And city by city, this sort of regulatory framework had grown up over decades, and it kind of locked into place a snapshot of the industry as it existed when those regulations began. It hadn't changed very much. And these new transportation companies didn't really fit into that model at all. They were the proverbial round peg in the square hole. Some of the companies took the approach of, well, we're not regulated, then we can do whatever the heck we want. And the incumbents fought back and tried to use the control over regulation, and indeed in many places, including here in New York, the commissions were very much influenced, if not made up of, participants in that taxi industry. The piece I want to pick out of that is this, that regulations, like law, are a product of their time. And the Supreme Court, when it decided some of these earlier antitrust cases, it had a picture of antitrust of the moment, and it had a picture of industry at the moment. And that's why it's important to look back at these two cases. Swift and Alcoa will be my initial focus, to see what it was that was in the court's mind when it set a framework for monopolization and attempt to monopolize the two principal offenses under Section 2. It's 1905, and the Swift case comes to the United States Supreme Court, and Justice Oliver Wendell Holmes writes the opinion for the court. Two things are very important to Holmes at the time. He is a student, as most of us know, of the common law. His most famous scholarly work was about the common law. And the Sherman Act was drawn from the common law, drew terms from the common law, and was committed to sort of following a common law approach. He also noted the unique fact that the Sherman Act was the first white-collar criminal statute in the United States. And so in his mind, he's thinking common law, criminal statute, and the instance before him involves the offense of attempt to monopolize. And so he writes that attempt offenses require proof of a dangerous probability of successful achievement of the end result. And that dangerous probability test becomes part of the law of attempt to monopolize. And the case he cites for it is one of his own decisions from the Supreme Judicial Court of Massachusetts, which was just a criminal case, a common law criminal case. And so dangerous probability of success becomes part of the law in 1905. 40 years later in Alcoa, Judge Hand sets what has become and persists as the basic framework that was used in Grinnell and repeated again by the court in Microsoft and repeated again by the court in Trinco, that the offense of monopolization requires two elements: monopoly power, willfully acquired or maintained. But what Hand does in establishing how we're going to prove monopoly power is he seizes upon the idea of market definition and market shares as the way to gauge market power. And that's sort of cemented a few years later in the Cellophane case, that we must define markets and we must, at the outset, evaluate market shares. And looking back at the prior cases of the Supreme Court, what Hand did was he came up with these rules of thumb. 90%, that's enough. Mid-60s, maybe not enough. And 30%, definitely not enough. And it's extraordinary that here we are, nearly 8 decades later, we still follow those benchmarks, and you still see the courts using those benchmarks to determine what is and what is not a monopoly. Now let's connect the two cases. So what does that do to the attempt offense, which wasn't really the focus of Hand's decision? It means that dangerous probability of monopolization means dangerous probability of reaching a market share that's at 70% or above. And there's a reason why we don't see very many attempt to monopolize cases today, because it is very rare that you're going to be able to prove the specific intent requirement and the dangerous probability that you're going to get from a market share of maybe 40 or 50 to 70 above. That doesn't happen very much by conduct, and it doesn't happen very much, period. So we have a framework that continues to be repeated by the court that has certain features that have become problematic. One is it is a sequential approach, especially true for monopolization. You can't get any place until you've defined a market and calculated a market share, and that market share is very, very high. That essentially, if you invert it, creates a safe harbor for unilateral conduct by anybody with market shares less than 70%. That's an extraordinarily permissive monopolization standard by world standards. Is quite unique in the world, actually, in terms of the prevailing thought about single firm conduct. And The attempt offense becomes almost invisible. You won't see it used very much in our law because of this linkage through the dangerous probability requirement to market shares. I did some research almost 20 years ago now on looking for cases, and the attempt cases tended to be about 50% or so, but very, very few winners. And none very recently have invoked the attempt to monopolize. So we wind up with a system that's quite different from the European concept of abusive dominance. It is very possible to engage in unilateral conduct if you have half the market. And unless it's going to create this dangerous probability that you're going to grow even larger, again, we have something of a safe harbor in the United States. No equivalent offense of abusive dominance. That law, which was supposed to be flexible, has turned out to be far less flexible than Section 1 of the Sherman Act. It's not to say that there isn't room for new economic ideas. I think the courts have shown their ability to deal with new economic ideas. That's part of what Harry and I wrote about in the Microsoft book. The court, although maybe it was an extraordinary court, was able to absorb new economic thinking into the framework of monopolization. But we've wondered, since we haven't seen many cases like that, whether it turns out that Microsoft is something of a one-off, very extreme facts. The bigger problem today, and I'll close with this and sort of pass to others because we'll be talking about this the rest of the panel, is what can be missed by that kind of framework. This almost sort of obsessive attention to market share analysis and market definition, as opposed to more direct measures of power, more direct measures of effect, could clearly be problematic in markets that are not structured like the markets of the 1905 or 1945, the more traditional manufacturing markets. The sequential approach can also be misleading. Dan and others may talk about this, but starting off with market definition, well, that was something that the 2010 merger guidelines tried to sort of move away from a little bit, acknowledging that direct evidence of anti-competitive effect is evidence indirectly of market power, and maybe looking for market definition and market shares is something of a distraction that takes us away from the more important issues. Maybe we need to evaluate systems competition in a different way. As Paul was talking about this morning, thinking about the different business models of today and what would be the best framework for evaluating that. And the last point I'd like to make is that we need to address the problem of incremental harms. I'm sure this will come up in the merger discussion later on today, of serial acquisitions over time, no single one of which looks particularly significant at the moment, but that collectively they do reveal a business model and reveal a pattern and a strategy that may ultimately prove to be anti-competitive. This was an issue that did come up in the Microsoft case. The phrase that was used by many was death by 1,000 cuts. That's what people in the industry were saying. And the antitrust laws are not really very good at dealing with death by 1,000 cuts. If time permits later on, I'll talk a little bit about some of the layered on assumptions and presumptions that have also added to the burden of proof in Section 2 cases. But I wanted to sort of just set up the legal framework, its origins, and hopefully illustrate that there is room for improvement and evolution just in the legal framework that we use under Section 2. Thanks, Harry.
Dan.
Thanks. I'm the only economist on the panel, so I feel like I have to prepare myself to defend myself from Paul Romer and others. To set my comments in context, I feel like it's useful to make the distinction that we hear about between those of us who might be seen as populists, and those of us who might be seen as progressives, and those of us who might be seen as more conservatives. So I put myself in the progressive wing, meaning that I am not convinced at all that some of the talk about major structural changes in the in our economic system are the right way to go. I actually believe that we can make a lot of progress within the context of the existing antitrust laws, but we have to push them pretty hard And so, even though I'm going to start off with something more radical, you'll see at the end of my 5 or 6 minutes that I will just suggest a few areas where I think we can push pretty hard within the existing confines of the antitrust laws. But to start off, I was at DOJ as the chief economist for actually about a 3-year period, during the period in which the Department of Justice filed 4 Section 2 cases. By my count, with a little help from Andy, DOJ has maybe filed 1 Section 2 case since. There may be more, but I couldn't find them. So it was an unusual period. The FTC, by the way, has a different story. Bill could fill you in if you want, or I could tell you. The FTC has actually been more active with respect to monopolization, but the DOJ has not. So, and of the 4 cases, US v. Microsoft has gotten the most attention, but I recommend reading US v. Dentsply, for example, another case that I was active in bringing when we were there. Now, with respect to US v. Microsoft, a big issue that came up was the remedy issue once the court had found Section 2 liability. And I actually, one of my jobs when I was at DOJ was to organize thinking about what would be an appropriate remedy. And during the 1 year in which I and the team of lawyers and economists at DOJ studied that question, I stress a year because it really took us a year of hard thinking to decide what to do. We eventually decided that it did make sense to break Microsoft into an OS and an apps company, 2 separate companies. My only question privately was which one Bill Gates would monopolize if he ran it afterward, but that's a question we didn't have to answer. That was my first joke. There aren't going to be many. So
It's an economist
hang
joke.
on to that one. We actually I hired actually Paul Romer and another economist, Rebecca Henderson, to present the case. And unfortunately, from my point of view, we never got to actually litigate the case. And it would have been extremely interesting because you would have heard 2 economists testify. As Paul said, his testimony, which stresses the importance of having 2 firms competing for market, is out there. Rebecca Henderson's work, I haven't seen as much publicly, but it was also very good. Had the case been litigated on damages, on remedy, we would have finally found out whether a court was willing to entertain this kind of radical remedy. Now, the reason why, and we never did get an answer to that, the reason why I thought that was the appropriate remedy was because of a couple things. One is Microsoft had not been terribly innovative in terms of the underlying technological innovation. It had been very good at acquiring innovations and marketing them and producing products that were very popular, which is very important, but it had not actually been doing the kind of innovation that I had seen and others had seen in the industry. And we thought that having competition between 2 companies, both of which would be reaching out to broaden their own functions, would actually generate more innovation. Now, why is this debate, which was never settled, important? Because in reality, it's very hard to know how these markets would evolve. There's so much uncertainty. And courts have historically been reluctant to put a lot of weight on questions that involve what will happen, more than, say, 2 years in the future. I think that case, had it been litigated on remedies, would have answered some questions about where courts were willing to go. Now, having said that I'm a breakup kind of guy, I have to tell you that I'm extremely hesitant to say that we ought to be spending a lot of time talking about breaking up the companies that Harry listed, Facebook, Apple, Google, and so on. And the reason why I'm hesitant is there are a couple of reasons. One is that there are huge efficiencies that have led to the creation of the monopoly power that a lot of these firms have. Efficiencies in terms of economies of scale and scope, as network effects and so on. These are real efficiencies. And perhaps something that might be more widely debated, the elimination of double marginalization costs. So if you talk about breaking up these companies in a way, particularly in a way would not be as natural as the apps OS breakup that we talked about earlier, you're talking about eliminating a lot of these huge efficiencies. And I just think that it's unlikely that that will happen, and it's going to take very strong evidence by both economists and testimony and by the lawyers to really get there. So I just actually don't think that's where we ought to be spending our time. So I want to keep my comments short, so I'll tell you 3 areas where I do see the possibility of movement that could be significant, and others have written about each of these. The first area is that I think we could look harder and push harder on vertical issues. I think there's a lot of behavior of firms with monopoly power that naturally leads them to think about extending their monopoly power into vertical markets. And I don't think we're thinking hard enough about that, and I think we can push harder about that. I know Steve Stalp, who's here, has written a very interesting paper supporting that view. I think that's a direction we have to look at. We have to look at really, really hard. Second area that we need to think about has to do with the fact that we have had active intervention recently and in the past by the states. I've actually counted at least 3 former heads of the New York Antitrust Bureau when I was looking around. I'm sure there may be more of you out here today. 4? Yeah, that's right. I forgot you, Harry.
That's right. Scott.
So, at least 4. So, why do I believe that? Because even though I worked very closely with the states in US v. Microsoft, it wasn't the easiest job, but we managed pretty well, Steve, to make it work. But I actually believe that we need to push the federal agencies pretty hard, particularly in times where the federal agencies aren't pursuing Section 2 cases, and the states generally, I think, do a good job in making that effort work, and I think we ought to see more of that. And I'm actually a big believer in this kind of federalism. If I can throw in a quick ad, I have a new book that I just finished, which will be out in a couple of months, called Democratic Federalism, and it has a little section about why I think federal antitrust ought to be allocated between the states and the federal governments. But it's really actually a broader theory that I've developed with a co-author at Penn, which lays out more broadly why I think we ought to allocate powers more broadly. So pick up a copy. It's really cheap when it comes out. That's my ad for the day. I've got 1 joke, 1 ad, and finally, my third area where I think we could go further, which Andy actually mentioned briefly, is I think we have to think harder about whether we need the formalism of market definition as we do in Section 2 currently. Certainly from the point of view of economics, it's not at all clear to me that we need to be held up by getting to huge debates about market definition. I think we can get a lot of action by moving more directly towards competitive effects. And an example of that for me would be, I've actually argued in 1 paper I wrote that it doesn't make sense to talk about search as a relevant market. My reasoning being that if you're going to talk about competitive effects, you need to talk about advertising. Why not talk about search and advertising as a market rather than search separately? Well, we could have that debate, but the fact is that everyone knows that search is significant and meaningful. I don't think that debate's terribly constructive. I think we ought to be just, if we're analyzing behavior of Google, let's talk about whether there are adverse competitive effects or not. And if I had more time, but I think I should stop here, I could tell you about a case I did for the FTC as an expert where all of my analysis involved competitive effects. I refused to say what the market definition was. The FTC went ahead, formally defined the market, of course, in its papers, and we won the case without any problem. So at least as an economist, I think we can be comfortable focusing harder on competitive effects and not getting caught up on definitions of markets that really are not terribly constructive. Thanks very much.
Great. Thomas.
Thank you for representing the European view. For the last 10 years or so, all major antitrust decisions regarding big tech came from Europe, while the biggest mistakes have been made in the United States. In 2017, 2018, and 2019, the European Commission fined Google a total of $9.4 billion for 3 different abuses of dominance. 2 weeks ago, at an oral hearing of the appeal of the first of those cases, Google Shopping, which, by the way, the FTC did not pick up in year 2013, one of the judges at the General Court suggested that the fine should be increased because of intentionality and because seemingly it didn't have any deterrent effect on Google, which just continued the very same conduct on other markets. But it's not just about the Google cases in Europe. The European Commission is also investigating whether Amazon is abusing its dominance as a marketplace, whether Apple favors its own apps on an app store, or whether Facebook shields off competition from its Facebook marketplace. In Germany, the competition authority has already found that Facebook's use of data constitutes an abuse of dominance. And following more than 100 complaints from merchants, it got Amazon to change its general terms and conditions on a global scale to better protect merchants. Now, what are the common factors of these European decisions? Let me highlight two. Firstly, European competition enforcement is really concerned about leveraging of power. There has been a long history of cases where there has been skepticism about a company that is dominant in one market trying to use that dominance to extend into a different market with means that are not available to the competitors on that market. Now, classical leveraging cases that have been condemned on both sides of the Atlantic, at least for a few years, are margin squeezes, tying, bundling cases, and certain refusals to supply. But there is not an exhaustive list of such leveraging practices, and actually the Commission's cases on favoring just deal with a new type of that market extension strategy. Economically, preventing and prohibiting such leveraging practices is supposed to spare competitors that just want to enter into the second market from also having to enter simultaneously the primary market that is already dominated by the company under investigation, because doing so would just create additional barriers to entry that no one really needs. So let me give you an example. It simply makes no sense if competition law expects a company that just wants to offer apps to first launch a very successful global scale app store on every mobile device. Neither does it make sense to expect a company that just wants to provide specialized search services, let's say to compare flights or hotels, to first set up a global general search engine such as Google's. In particular, if you know that even Microsoft failed to do so with Bing. Preventing such unnecessary barriers to entry is really at the heart of the European Commission's cases about platforms favoring its own services. Now, the second element in the Commission's enforcement policy in digital markets is that due to the strong positive network effects that are present, the authority does not need to demonstrate and to prove that there is already an actual injury to competition. Instead, it is sufficient if the competition authority can show that the conduct is capable of having such effects, and likely that equally efficient competitors are foreclosed. Now, this much lower threshold is crucial when it comes to intervention in digital markets, because they are fast moving and there is a risk that they tip and that this tipping is irreversible, so that antitrust enforcement simply comes too late. In a winner-takes-it-all scenario, antitrust enforcement that only kicks in once a competitor has a dominant position is simply useless. It comes too late. It cannot remedy anything anymore. And that, unfortunately, seems to be the situation in the United States at the moment, because, as Andrew already pointed out, following the Trinco decision of the Supreme Court to bring a leveraging case, you have to show that there is a dangerous probability of success, which means you have to show that there is already a dominant position on the secondary market. But if you wait until that point, the whole operation is useless, because the patient, the competition for the market, is already dead. So in my view, this case law serves as a very poor basis in digital markets and kind of needs to be adjusted, because in these markets, it simply will not work. But let me also point out that it would be exaggerated to suggest that Europe got everything right. The investigations are still taking too long. There are no clear guidelines on multi-sided markets, and some of the remedies that have been imposed by the European Commission simply did not work out. Nevertheless, the relevant institutions have learned their lessons. And over the next couple of years, you will see fundamental legislative reforms relating to antitrust law to address the current shortcomings. Earlier this year, Germany already published its draft bill for a new modern competition law act, and it contains such innovative, groundbreaking aspects such as data portability, access to big data, securing of interoperability, preventing that someone harms or makes it more difficult to multi-home, preventing that others can attain positive network effects, securing that there is no self-favoring, things like that. Similarly, last week, the European Commission announced that it intends to enact a similar legislation, also to ensure that platforms that the Commission has identified as serving as sort of a private gatekeeper for entire markets, for customers and for information, so the companies we are talking about today, that these companies are not taking advantage of their strong intermediation power to basically distort competition in every market that they like, and to favor any service of their own if they so feel like it. And my hope is that maybe some of those approaches could also be considered in the United States, and I'm looking forward to discussing them.
Thank you. So I have, let's say, 2 points I would like to make, or 2 big areas I want to talk about. The first is Section 2 of the Sherman Act, which is our unilateral conduct statute, and the crippled, that it is, I want to assert that it is a crippled way to consider enforcement against unilateral acts. Second, I want to say a word about the world and the fact that everybody else is enforcing and seems to know where they're going, and U.S. has loads of investigations, but we may or may not take, U.S. may or may not take any action, and we have become a little bit irrelevant in the world of unilateral acts for antitrust violations. So on my first point, I'm much more depressed than Andy about the possibilities of using the framework that we have under Section 2 of the Sherman Act to take progressive action that would in any way even dent the power and abuses of the big tech firms. Section 2 of the Sherman Act, as interpreted by the Supreme Court, is very, very narrow. And of course that means Trinco and Linkline. And then you can take also, just moving it into the larger view of the Sherman Act, Amex, American Express, Ohio. The framework is very crabbed. There are very few actions that actually will be violations. It has huge fault lines, and when you try to apply it to the big tech context, you see exactly the fault lines. In other words, it's not very sufficient to rein in power of the big tech. So let's just talk about hurdles under Section 2 for a minute, using the big tech examples, and perhaps we should say a few things about what are alleged to be, and in some places found to be, the abuses of big tech. And these include, they've been mentioned here, but they include where you have a dominant platform, such as Google, and of course, such as Facebook. The dominant platform tends to engage in the following kinds of acts. It will demote rivals because they're better. It will sabotage rivals. This is rivals on the platform who are competing on the platform, but are not the gatekeepers because, of course, Facebook or Google is the gatekeeper. They will cut off data as a punishment if a business on the platform is competing too well. It will, and picking up from some of Thomas's examples, try to assure that data are not portable and try to assure that the systems are not interoperable. and try to assure that multi-homing is not easy. And then also, of course, the acquisitions, which could be monopolistic acquisitions, try to assure that nobody out there is going to be able to grow to be a competitor. These are all very distinct conducts that could, in theory, be targeted very specifically, and in theory, but maybe in a different world, easily and without too much time. But they are not easy to attack under US law. Whenever there is a claim of duty to deal, it's usually the claim is knocked out under US law. We do have some spots of sunlight sometimes, and one was the Comcast case that was handed down by the Seventh Circuit a couple of days ago. But I would say, as Aristotle did many years ago, a sparrow does not a summer make. And indeed, winter is coming. The judiciary is becoming more, and the judiciary below the Supreme Court is becoming more and more conservative, like Trinko-Linkline of the Supreme Court. So we can make arguments within the framework of Section 2, but they're not likely to win. So here are the obstacles. There are obstacles at every single phase. Obstacles in defining the market in view of the difficulties Ohio against American Express and pushing towards two-sided markets when the particular harm might be more clearly like using search leverage to prevent the competitors from arising on the platform. You have to get past market definition, and Ohio versus American Express does indicate that it's going to be hard to get to Dan's proposal of using conduct harms and effects and avoid market definition. So in Ohio American Express, the court said, if it's not a horizontal case, you really have to define the market. So defining the market's a hurdle. After you define the market, finding market power is a hurdle. And even if you have 80–90% of, say, Google and search or Facebook and social media, there are really good arguments, given the technicalities of our law, that the big tech companies have, that they don't have market power, that the competition is, as Google says, a click away. Another huge hurdle. And then the third huge hurdle is, even if you get past that, you define the market, you've found market power, and you get to whether this conduct is anti-competitive, you have really big hurdles because the platforms say, look, we're giving this to you free, and consumers are really wonderfully off. And the competition is a click away, so we have competition always breathing down our necks. And you have improved output limitation and price effects. Our Seventh Circuit case that just came down said you might not have to, but I think under Trinko and the winter that's coming, you might have to. And the very fact that there are all these zero-price markets is going to make it very difficult to win. So I think Section 2 is a real problem, and the framework that we have to get over to get success in the cases are a challenge that we'll sometimes win, but we shouldn't have to face. I think, this is just one more word on my Section 2 framework before I say a word on international. I think that the Federal Trade Commission, I think I might have heard you say this, Bill, before, but you can tell me if I'm wrong. The Federal Trade Commission has the flexibility to take up the slack. It has unfair competition jurisdiction. The Supreme Court under Section 2 has cut back Section 2 partially because of reasons of private actions. That if you get a judgment under Section 2, the private parties can take advantage of the judgment, and they can't in the Federal Trade Commission. So Section 2 has been cut back and does not prohibit all that is anti-competitive, almost admittedly. And the FTC could take the steps of presenting a different framework, a new framework that isn't so crabbed and isn't so unsympathetic to those who are left out of the market and is much more sympathetic to the incumbents who are in the market. FTC also could do rulemaking And it could do rulemaking on antitrust. And it could do rulemaking in this area where I will claim that it's an area you could say it's some combination of unfair competition and anti-competitive. And that shouldn't have to matter. For example, what I'm talking about is if Google is using its algorithm so that anytime any firm is competitive, it demotes it, those who are technocratic sticklers for proving harm in terms of getting monopoly power in a second market probably can't do it. And so this half the world will say that's not anti-competitive. At most it's unfair. And some will say we don't want to get into unfairness jurisdiction because we know that protects competitors from competition, which has been the mantra for so many years. And I'm saying there's this huge space where you're not protecting competitors from competition. You're protecting their clear path to succeed on their merits. And if you want to call it unfair competition, it doesn't matter. It shouldn't have to matter in the FTC. The FTC could actually make rules very targeted at those very specific conducts that between Thomas and me, and we mentioned a lot of those very specific conducts that the big firms that have big data ought not to be able to bludgeon firms that are trying to compete on their merits if they don't cave into the big tech demands. Okay, so going on, just a word about the world, and since the world is big, I have to say a tiny word about the world. I think, U.S. is a pebble in the world. In terms of the enforcement side, everybody else is setting rules for enforcement and what is illegal. U.S. is almost irrelevant. And that's one piece of it. The other piece is we are in a world problem. These markets are international. And each of the jurisdictions is actually becoming more nationalistic, which is a real problem. This is a conversation that really has to be had on the world level. It has to be had among the enforcers of the world. The International Competition Network is a good place for launching the conversation. And so what is the conversation? I mean, one part of it is to say, thinking of the world as the market, what are good antitrust rules to maximize markets, robustness of markets, some combination between consumer welfare and simply robustness of markets to preserve the competition and create the conditions for innovation. Thank you.
Thanks to Harry and Eleanor, and in particular the pleasure I have in sitting next to Eleanor, who has forgotten more about this field than the rest of us will ever learn. Truly is.
And that's nothing.
There's no,
and that's nothing.
There's no exaggeration about her unequaled contribution to the field. I'm going to start by assuming that there's not going to be a new wave of legislation anytime soon. Maybe that'll happen, could, but I'm going to assume that that's not going to happen. So I'm going to focus on what you might do with what you have right now. That is, there was a Saturday Night Live skit a long time ago about how Waterloo might have come out if Napoleon had had a B-52. He didn't. Probably would have come out differently, depending on how he used it. So I'm assuming there's no new remarkable divine intervention to provide legislation anytime soon, so you use what you have. I think that there's a greater path of possibilities than one might think. And to do it well is a mix of thinking carefully about what you actually have, doing an accurate stock taking of where things are, formulating a strategy that involves principally public initiative, government acts, for a reason I'll mention, and to do it in a way that's willing to accept risk, to change the risk appetite, and to gain approval through the larger community for doing that. My own views are heavily influenced by my own experience at the FTC, but also in the last 5 years of the Competition and Markets Authority in the United Kingdom. For starters, you have to begin with a strategy. Suppose that you want to extend the frontier. You have to start with a strategy. Question, to what extent do our public institutions have a common strategy for what to do and how to use their resources. To what extent have even the Federal Trade Commission and Department of Justice sat down and said, let's simply do an assessment of where things are now and where we want to go? That hasn't happened. Oh, there are conversations about some coordination taking place. But we have 3 institutions that do not have a common program. And what would a common program be? Where do you want to move the frontier? 3 categories. Where are analytical tools broken and have to be replaced? Where are they, in a sense, blunted and have to be sharpened? And to the extent that you have discretion to do so, what new ones might you try to add through litigation? But what's the common program? What are you trying to do? We don't have it. Turn to Europe for a second. In the United Kingdom, you have a thing called the United Kingdom Competition Network, which joins up the CMA and sectoral regulators in a common program that involves a common strategy. And in the European Union, you have a thing called the European Competition Network, which initially was thought to be just a mechanism to make sure that the member states and the Commission in Brussels did not cross wires, a bulletin board to keep everyone aware of who was doing what. But it's really become a way of thinking not just who's doing, but what should we be doing? And you've seen the emergence in the last few years of a much larger number of common projects that link the member states, sometimes Brussels as well. You have the public institutions realizing that individual initiative will not be enough, and that in many ways the existing program is not sufficient. Thomas mentioned the Google fines. I know what the big reaction is in Europe. Indeed, if you give truth serum to the enforcement officials, 9 billion euros, so what? Who cares? Now, would Google rather have $9 billion than pour it into the treasury of the European Union? Yeah, I suppose. But does it really matter? Not much. The commissioner, in effect, has said so. So, the larger question of what we do and how we do it, a sense in which the rest of the world, at least Europe, United Kingdom, I say, much more recognition by the public institutions that you need a joined-up effort. I suppose I could start right here and say that's not going to happen here. It just won't happen. Too many tensions. The FTC and the Department of Justice are much more than 2 blocks apart from each other across the universe. And that probably won't get better, even if you have a common view by appointees of what ought to be done. An example, Dan mentioned remedies. I don't think Dan and his colleagues ever thought, the FTC has a provision in the statute that says that we can ask the federal district judge to enlist the FTC in an effort to serve as a master in chancery to assist in the formulation of the remedy in the case. I don't think that even occurred to the department as an option or as a possibility. Maybe to take some of the weight off of Judge Jackson's shoulders, and indeed, Paul's remark about a single USDJ having to decide these matters in isolation. Why did Judge Jackson make an incalculably damaging step of talking to so many journalists during the case that nearly destroyed the case? Why did he do that? Because I think he wanted a focus group. And the journalists I've talked to said he wanted to get some reassurance about what was going on. So you could have joined up, even in Microsoft, a larger array of government resources to do things. That didn't happen, using tools you already have. So one thing to begin with is a common strategy. The common strategy to work, I think, is going to have to focus on the likelihood that it's going to be a government case and government litigation that will move the boundaries. Where's the place to look most? It's to read Justice Breyer's concurrence in Linkline, where he said, if this had been a government case, I would look at this case differently. The last time the US government or the states appeared before the Supreme Court in their own right as a party in a Section 2 case was 1973 in Otter Tail. Amicus appearances, sure. But the last time the US government stood before the Supreme Court and said, we represent the government of the states or the United States, this is our case. Supreme Court, if you're worried about private trouble damage cases being the pirate ship of competition law enforcement, Incorrectly, but if you believe it, we're the Red Cross. So we don't carry the other baggage. You can trust us. That's part of the strategy. To say, how do we move that case to the court? So it's going to be a government, and you look at Linkline, you look at the Breyer observation, there's a big difference between the government as the plaintiff and the private sector. To make it work, I think we've learned from the past, you need a large inventory of cases. You can't just have one or two, you probably need to be running 5 or 10 at one time. And some of those have to be small cases, not the fixation on just bringing the big case. That is, if you look at dealing with concentration, market power now as being the equivalent of asking, how do we go to the moon? It's 1961, how do we get there in 1969? It's going to be an aggregation of steps that take place over time, in which, in thinking about where you want to improve tools or move boundaries, you look for some small cases too. What single case in the Section 2 area has probably provided the most useful analytical device for plaintiffs, public and private, in the last 60 years? That's Lorraine Journal. Now, if you were looking in a grand sense, in looking at, well, where do we get the maximum economic significance? Do you even think about bringing Lorraine Journal? That's a time when the Department of Justice is being screamed at to break up General Motors, the petroleum sector. They brought Lorraine Journal anyway. And part of what dismays me about the modern conversation about competition law is the suggestion is, if you're not bringing the big front page cases, you're missing a great game. I think back to my time as general counsel at the FTC over a while ago now, where one of the things we identified internally is that the rule of reason was broken. The California Dental had broken it, and the question was, how do you repair it? How do you restore an intermediate standard known as a quick look? You look for cases to do it. What was the first one, knowing where we wanted to go, that came up? That's Polygram. Now, is Polygram a big stakes case? No. Did it deal with staggering, momentous matters of domestic commerce? No. It was a great case, though, as a tool to build an analytical building block that you could use later on. So, you have to have a portfolio of cases, and some of those have to be small cases, realizing we're not going to fix this in 2 years, but maybe we can do it over a decade. And here are some of the building blocks, big cases and small cases. And yes, you have to rethink what your risk appetite is. An issue that comes up at every CMA board meeting that we have, that we never had at the FTC in a comprehensive way, that our public agencies do not do in a joined-up way, is that what should the risk appetite be? I think you can take on Trinco by going to the court. I'd be willing to do it and ask, what's the right case? You're worried about importing a regulatory norm from a separate area into Section 2. That's the holding of the case. You don't have to go beyond that. I'm not so scared about Trinco as decisively saying all refusals to deal are out of the question. But you have to look carefully at what Trinco did and then think, I want to be running a couple of cases to challenge that and to work with that. And to take the chance that I go to the court and say, here's what's going on, and we're willing to lose some cases. What's the risk appetite? That's why I would love to know why the FTC walked away from its Google case in 2013. What was that conversation like inside? What was the conversation like at the Department of Justice from 2009 through 2016, when there were a number of suggested possibilities for cases, but we got basically nothing, including from a number of spokespeople who say, now the system has to expand and do a lot more. And my question is, in a neutral way, is why didn't you do more then? And the reason to ask is, what was the risk appetite? And does that consciously have to change, and how do you transmit that to your staff to move ahead? That has to be part of the strategy. Last thought, and Eleanor, you're right there. The FTC in Section 5. Okay, here's the gloomy prognosis. How many times has the FTC in any case prevailed in what might be called a Section 2 case before the Supreme Court since 1914? Short answer, 0. Never happened. In that subset of 0 is the application of Section 5 of the Federal Trade Commission Act, 0. So no successful FTC appearances before the Supreme Court in 100 years. You might say that's a long enough time to test whether that model works before deciding to do something else. Rambus, was the case that could have done that. Rambis, in many ways, is the biggest Section 2 disappointment in our field. That would have been the one that would have done the trick, and it didn't. So what do? I think you look and say, you supplement the Section 2 program with Section 5 cases that try to do what Eleanor said. You're going to have to stretch. But you have to do that by using the other analytical tools you have to build the empirical basis for stretching where you want to do. It's there. It could be done. But it won't be done in 1 or 2 years. That's, again, thinking, what are we going to do over 5 years to be in a position where we can make this work later on? I don't know in our system that we have the patience to do that. To say it's going to be a mix of efforts for 5 years. And my final thought, well, I said I wasn't going to rely on new legislation in one sense. I'd pay for it. Why historically have so many of the big cases failed? It's because we don't pay for it. We pay peanuts for competition enforcement. And I'm not thinking just about adding more bodies. I wouldn't just want a lot more bodies. I want to pay market rates. Ellison and Jones and I have a proposition in a recent paper about what to do about building capability. The modest proposal is you put the federal agencies in antitrust where the CFPB is, which is basically a 20% salary boost right now. So you go up 20%, which helps you keep more of the good people. But Ellison and I say we give the Federal Trade Commission as a test bed, give them $1 billion a year for 10 years. And you go out and hire all the people you want. Paul Romer talked about the mighty forces of opposition you face. Yeah, they'll be there if you do anything that hurts. But I want to hire the elite team and see whether paying market rates, $1 billion, that's a 3-fold increase in the FTC's budget. I want to see what kind of people you can hire with $1 billion a year for 10 years, and then bring it on. But my suggestion is if you stick with the existing compensation salary and you tell people just go bring the more cases, rougher and tougher, bolder enforcement. I've seen that movie before. That was the 1970s. And it has a grisly end. So, if you want to do this in a way that works and really see how well the car will drive, the way it's designed now, you pay for it.
All right, I like that idea. Certainly, our students who are sitting out there would like that idea, and since that's
so would appointees to the commission.
Since that's how we attract students to the law school. Okay, incentives is everything. So there's a lot going on among our panelists, and as I said, I want to try not to be overly pessimistic about what can be accomplished, whether legislatively, maybe let's put it to the side for the moment. We'll come back to discuss it later on, I think, today. But in terms of what we can possibly do in the courts now, one of the things that threads through everyone, I'd like to get the views of the panelists, and if you have other comments to the panelists at the same time, that's fine too. But the question of market definition and whether our emphasis on it, the court's emphasis on it, is misplaced. I think Eleanor pointed out, maybe others, that whatever we think, there may still be a hurdle there in terms of talking to the courts today as to what they require. But in the big cases, and I'll put aside Bill's good observation about we should also have, I like the also have, maybe some smaller cases, I would say maybe we should also have some bigger ones. In the tech platforms we're looking at here, it's a problem, it's a hurdle, but seriously? I mean, Facebook's doesn't have monopoly power in social networks. Did you see the movie? I mean, really? Google doesn't have a monopoly in search? Where? I mean, come on. They're coming close to monopoly in browsers with Chrome. I mean, yeah, it's a problem, and it's a costly problem. Did Microsoft not have a monopoly in Windows? Come on. This was the easy part, except that it's costly. I get all those things. So we'll solve that with Bill's market rates, fine. And siphon off some of those fees from the Hart-Scott ridiculous filings. So let's get over that hurdle. I'm not sure that in the end, that's the hurdle. I want to focus in a little on the conduct, because one of the, the branches that economists hold out to us is we can look at it in price effects for advertising, let's say. I wonder, first of all, the problems of proving price effects. A couple of merger cases have not gone so well in that area. But the second is a lot of the things that generally is the complaint and that specifically is the complaint actually don't involve price effects, but effects on competitors. And I'd like to hear a little discussion about whether that should be what antitrust deals with or not. When Snapchat complains that Instagram doesn't show its filters trending, whatever the hell that means, that's something the antitrust laws should deal with, or when firms that use open source software compete against Amazon on the cloud, and then Amazon uses their stuff. Should the courts get involved in those things? These are the complaints. Read the newspapers. These are the complaints that competitors are bringing to the enforcement agencies and asking them now to deal with. And I'd like to get the views, first of all, whether, proving a market is really such a hurdle. This may involve markets for free goods. And second, whether we really can deal with or should deal with these kinds of complaints about conduct. So, Dan, I was thinking we should do this like the Democratic debate. Yes, I have an answer. So, Dan said, yeah, so go ahead.
Oh, I don't have an answer, I just have more questions, but.
Nobody raised their hand, right. It's not like the Democratic debate.
There's a real task for economists here, as was suggested by a lot of the comments. And the task I see for my fellow economists is a couple of things. One is understanding that the real action is what are the effects on competition? Are competitors hurt by what's the kind of behavior? How do they react? For example, I'm still struck by my time at DOJ when we were investigating Microsoft, and one of the tasks I had was to travel around the country, which mostly meant going to Silicon Valley to talk to a lot of the competitors of Microsoft. And it was an unusual time because many of my meetings were secret. They were held in hotel rooms. It was like a spy movie because no one wanted publicly, and the competitors did not want publicly to let it be known what they're doing. And I still have memos that I've never talked about publicly where I had to change the names of the parties I met with and so on and so forth. I never thought I was going to be in a spy movie. So, and that really caught my attention. I mean, we really have to understand who's competing currently, who are the potential entrants, what's their behavior like, are they being adversely affected? You don't need to talk about market definition to do that. The other point I would make is for economists, for my fellow economists, is we are moving away from price. A lot of the action is non-price behavior, and we really need to understand more about effects on quality, effects on innovation. And we are making progress. There's really a literature developing, for example, that helps us understand more accurately what kind of innovations are likely adversely affected by the loss of competitive, actually successful competitive behavior. So we have a lot of work to do. And I will save a discussion off the record with Bill about how easy it was to go across the street and talk to the FTC about remedies, but that'd be a private conversation.
It's hard enough to talk to the states, yeah. Thomas,
I would add to that in Europe, defining the relevant market and finding dominance has not really been the big issue. The definition of the relevant market played a role when it comes to the affected market to see, does this conduct actually have significant impact, or are there actually so many stronger players that don't really need what has been withdrawn from them that it doesn't have a big impact? But when it comes to finding the dominant position of the undertaking under investigation, that was not a big issue. And also the zero price problem, it has been very early on recognized that in multi-sided markets there are zero price market sides, but that shouldn't prevent competition law from applying because we all know about the interdependencies. So I think the real difficulty here is more to assess the interdependencies between the various market sides, what impact one has on the other. And this also relates to pricing. I think in these scenarios, there are much more indirect price effects. Let's take the Google Shopping case, right? Okay, the product you offer to the searcher is for free, but the more you commercialize and monetize the other side, the advertising side and the websites that you gather, the more expensive the products become because they have to spend more and more money on advertising. And where do they pass the money on? Well, to their own products. So actually consumers have to pay more when they purchase products on Google. On average, there were studies, you pay 15% more for products that you find on Google than on the most leading comparison shopping services. But this is a much more indirect price effect that doesn't really directly, is not the direct impact of the conduct. So price effects, I think, can't play a significant role. German and European competition law therefore have much more focused on limitation of competition as such, and they presume that automatically if you have less competition, it will have detrimental effects. And if these materialize immediately or 10 years later, because the companies just wait till they have full monopoly power and then recoup their investments, can't play a significant role. We have seen it in so many markets where companies just wait till they have gained the whole market and then maybe 5 years later, whenever they want, they monetize it. So, to bring a case and you have to wait to see price effects probably won't work.
Yeah, Eleanor and then Bill, yeah.
Okay, so I want to say a word about effects and competitive effects and what is an anti-competitive effect. And I want to end up actually by asking Thomas a question about it. I think we are at a point when we talk about big tech, when many people talk about the harms, they're talking about a conflict of interest, the gatekeeper type problem, that the gatekeeper, the dominant gatekeeper that has this huge amount of data and network effects in its favor, is using its position to get a very important competitive advantage over rivals. So the rivals can claim, or a competition agency can claim, that harms competition because the rivals would have been more innovative, and it's a harm to innovation. They also claim that just getting a significantly more market share is a harm to competition. That doesn't satisfy at least the conservative view of US, which says you must prove an increase in market power. And in the Google Shopping case, this comes to roost because there are a lot of situations, because the various countries are separate markets, a lot of situations in which Google gets a lot more market share. It actually has demoted its rivals. In some cases, some of those rivals have gone out of business. But it might not be provable that it gets more market power, even if you're not a stickler for saying increase in price. So the question is, what is harm to competition? Does EU even nudge up to requiring proof of more market power? And if it doesn't, are you more in a position of just assuming harm to competition from taking these advantages? One more word, which in Germany's amendments, it actually made it easier to make a case under abuse of a superior bargaining position. And a lot of these cases fit really neatly into this is an abuse of a superior bargaining position. And there is some space in the US, lots of space, between, we don't even have the concept, but the idea of abuse of superior bargaining position and getting more market power.
The competition authorities, because they've had vast experience, certainly in the US, it's unsurpassed, going back 130 years now, come July. They've accumulated over time what could be called big antitrust data. A lot of it dealing with the prosecution of individual cases, studies. There's a very healthy effort now, I think, to look at that big data more to mine it, especially older episodes, and to extract some lessons from it. And I think one of the most important that comes from it is that there's been a deep-seated concern from the beginning with non-price effects. And if you take a comprehensive list of complaints, going back through the old CCH Blue Books and going back to older annual reports, what are agencies talking about? Are they concerned about prices? Sure, but they're concerned about innovation. There was a wonderful, at least implicit cooperation between the Department of Justice and the FTC in the late 40s. The FTC did lots of market studies identifying cartel behavior, patent policies that arguably had restrictive effects, and the department tended to bring the cases. It prosecuted big cartels based on these and did others. What did all of these reports and studies talk about? Price effects as a secondary concern. Primary effect, innovation. So it's not shocking that this would be a matter. What I think is forgotten is how integral those concerns were to the development of cases and specific observations one can make about what happens when you intervene. Now, the results of the intervention are very unpredictable, but there produces, in some areas, a certain confidence that even if you don't know what the payoff's going to be, there's some reason to believe it can be extremely fortunate, which brings you back to the question, what kind of risks do you want to take? What's the conscious process? What's your strategy? But we've done it before, and there's a lot to study there about how to do it. So the critique that the modern program is trapped in a price-only model is not faithful to what's happened in the more recent and more distant past. If you study it carefully and you look at it, you can derive a lot of useful knowledge about what to do the next time.
Andrew?
Yeah. I'd like to make a contrarian point because I think there's an elephant in the room that we haven't really addressed from the beginning of the day. If we think about Microsoft, Amazon, Apple, Google, Facebook, I think it's hard to deny that part of the reason they grew so quickly and have been so successful is because they produce products and services that lots and lots of consumers really wanted. And that's part of what makes this a very hard policy issue. It's part of what makes it a very hard antitrust issue, is we're hardwired to think, first thing, do no harm. And when we start thinking about breaking up companies, we do worry about that. And if I were to do the Paul mechanism of asking for a show of hands, how many in this audience use some product or service from any of those companies? I think all the hands would go up.
Don't take my Amazon away.
So don't take my Prime away. Not in my Prime backyard might come out. I think that's part of what has made this a very, very difficult set of issues. They did not grow because they weren't producing something very valuable that consumers flocked to. And I look around the room and I imagine all of the phones and all of the laptops and all of the tablets and the ways in which we have used this technology to connect with each other. And I think that it cannot be left out of the discussion that we have deprived extraordinary benefit. And the trick is, now that we have fears about the growth and influence of the companies, how do we strike that balance? How do we make sure that we preserve some of that benefit, much of that benefit? I think that's what always makes for a hard antitrust case, when there's benefits and harms. And I think it's what makes hard decisions ahead about what to do with these large companies, which are, yes, all large, but in some ways they are also very different.
Yeah, the differences are important. I want to, actually people there are raising their hands as opposed to you guys. So we're going to cut into the coffee time few minutes, and we've got a question there, and also Steve Salop, I see, has his hand up, and the third Mike Biowitz.
Thank you, Christoph Slaak. Listening to all the contributions, I think the seminar should have been called "We Want Action," because I hear from everyone that something needs to be done. And I was very happy with the last remark that action needs to be very careful, because I think very positive things have come from all the big techs. And I think we need to be really careful before we take action. And we've seen in Europe examples of national competition authorities who have taken action based on abuse of dominance because they saw conduct that they didn't like, didn't find the appropriate legal tool, used the abuse of dominance tool, and put in the finding decision, this is an innovative application of the abuse of dominance rules, and imposed subsequently the biggest fine they have ever done. And this was in the Netherlands. And I'm basically asking at the panel, how do we make sure that we find the right balance? Because there is an eagerness, at least in this room, to take action and immediately, but I caution, we need to do this carefully because there are examples out there where the authority went too far, too quickly, and I'm not sure whether that's a good thing.
So what I'd like to do, we have 3 comments up. Let's tee up the comments and then the panel can, we may have, well, I asked Steve first, but Paul then gets you've already spoken, Paul. Okay, Steve.
I actually have a question. I mean, I'd like to know whether you guys all think that economics has had a bad influence in the end by stressing the need to quantify effects, which number one pushes you into looking at price, because that's the easiest thing economists think you can quantify. And secondly, by using econometrics, you tilt the playing field against the plaintiff, because the statistical tests in econometrics are based on avoiding false positives rather than also being concerned with false negatives.
Paul, and then Mike Biowitz had his hand up as well.
Draw together some of the links in the discussion. One of my points was the same question which was asked, and based on the discussion Bill gave, it sounds like there's a case that antitrust worked better before economists were involved. I think we need to actually take that seriously.
Right.
I also want to just note that the strategy you're suggesting for improving antitrust enforcement was used in reverse by Boeing to eviscerate the FAA. So I think you're exactly right that resources are at the heart of whether the government can do its job. And then finally, I would trade away everything that we've gotten from the tech sector in the last 20, 30 years in a heartbeat, except for Wikipedia. Because Wikipedia doesn't need all of this, all of these business models we're so eager to protect. So I think this idea that, we got to be careful about doing no harm, we're doing massive harm right now. And I just think it's, I'm just a big enthusiast for the tech sector and what was going to come out of it. I think it's just been massively negative net social product, and we need to come to terms with that.
Wow, okay. And Mike.
Yes, I'll come at this from a somewhat different perspective. I think it is very important. I start with Andrew's observation, and that it's very important to figure out why conduct is actually anti-competitive. And I would think, as somebody who's been a practitioner, spent my whole life looking at facts, that the reason why these firms do various things is very important. And if you're going to go towards something that doesn't start with market definition, you start with why are they doing it? Is there a pro-competitive rationale for why they're doing it? And if so, perhaps be allowed. Second one is a lot of the complaints I hear, and I don't listen to them as closely as other people in this room, but a lot of the complaints I hear about this sound like a bunch of free riders who didn't create the system wanting to get the benefit of it without paying for it. Okay? So when they say that, I've got to pay more in order to jump my place in the line for advertising, well, why shouldn't they pay more? Okay? And then the last one is, why is it bad to pay more for products on Google if it's much more convenient to buy it that way, and that's what consumers want? My concern at the end of the day is I've heard a fair amount of assumptions that what is going on is bad without hearing a lot of facts that prove that it's bad.
So from different parts of the room, it's all terrible, maybe it's good. And, you know, in some ways, that's where our debate is. So I want to get the reactions of the panelists to any of the comments. And we don't want to forget Steve Salop's comment either.
Maybe I start with the last comment. You mentioned that you've been following most of the cases. I think there's probably a point in it, because it's not about free riding at all. There were services that were market leaders in their places, the best you could have. They have focused on that for years. They were the absolute top-notch companies. And then others, the biggies, just came in and abused their dominance and wiped them out. Now, there's no questioning that has nothing to do with free riding. It's just someone exploiting its dominance in one market that we all need, which is general search, to wipe out competitors that were actually much better, much more innovative, cheaper products, much more qualified than the products the big tech had. And that is all proven. Just look in the decision of the European Commission, and there is nothing about free riding. It's about a poor product of Google being favored so that the actual specialists in the field had to leave the market. And to take the point about not rushing in, well, the Commission certainly didn't rush in with taking 10 years. But if you want to prevent that, just increase the resources of the authorities, as has been suggested here, put more money in it, make sure that there is better disclosure system, make sure the companies cooperate better. Yesterday we had to read Google is just not providing the information to the authorities. I mean, then what do? You have to create a system where there's information asymmetry between the big companies that don't say anything about their business conduct and the poor authorities that try to understand it is somehow limited. But that is not a problem that is, handmade. It's basically inherent in the system, and the authorities have to battle that. But the only way is to actually be proactive on that and not to shy away and say, well, it's all too complicated. I may make a mistake because I don't really understand it. Then we will never solve a case. The solution can only be if you feel you don't have the weapons to fully understand what's going on, then your weapons need to be stronger, or you have to oblige the other party to help you a bit more to understand what they are doing. I think that's what I want to say on that.
I do wonder, to address Steve's question, whether the emphasis on quantitative measurement has been an obstacle to good analysis. Older cases had strong economic content. They did. Not expressed the same way, maybe not injected into analysis the same way, but it was a more narrative style of study, more case study based, not high-tech mathematics. Perhaps in many ways that got lost, and especially when it came to making predictions about actual or likely effects going ahead, which is why I think the historical perspective that comes out of some of the older cases suggests a different way of trying to predict what those effects might be. So I think for the, especially in merger review, is the government, and I borrow this from conversations with Andy, is the government going to be stuck in every merger case now to come up with very precise, well-measured price effects for individual transactions in order to get a prohibition decision? That arguably is quite unwise. And is it digestible by the courts themselves? I wonder. But older cases did use important economic insights and made rough assumptions. The decision, say in the late 40s and early 50s, to focus on IP and patent licensing made basic decisions and relied on an intuition that this would open up innovation in markets. And could they prove it rigorously? No, they couldn't. But I think the results, that intuition was borne out pretty well. And I'm a big fan of, I know case studies can be unrepresentative, but whether it's studying how Boeing strayed from a much more responsible path in product development over time and lapsed, how government agencies make decisions. What's the business model for a public agency? What are they maximizing? And how do they go about deciding? I'd like to see more of that kind of examination as a way of thinking, not just whether the judgment made was good or bad, but how to do it better the next time.
We are now seriously cutting into your coffee, which is always a bad idea. And somehow we didn't solve all these things in an hour and a half. So we're going to continue the discussion. We'll cut the coffee session shorter than it would be so that the merger panel can go. So let's try to do this in 10 minutes, and thank you all to the panel.
I think you're right. I think you're right. I think you're right. I think you're right.